Good morning and welcome to another edition of Jus As They Speak, an academic initiative by the School of Law at SASTRA University as part of the Nani Palkiwala centenary celebrations this year. Today we have with us a jurist, an experienced lawyer, a former judge, an accredited mediator of international repute, and first and foremost, a scholar, Justice K. Kannan, former judge of the Punjab and Haryana High Court and former chairperson of the National Railway Claims Tribunal. Justice Kannan is not new to us. He has visited the School of Law for a special lecture in 2014, and that is very fresh in my mind. And say a few words in his honor, I can only go back some years to the Law Weekly, which wrote a beautiful piece on his elevation. And I can say that Justice Kannan is a third generation lawyer, and his father, late Mr. M.N. Krishnamurthy, was the Sir Alladi of the Kadalur Bar and a very experienced hand in civil law. And spending his initial days of apprenticeship with his father, he built a formidable practice in the civil side. And later came to Chennai in 1992. And it was never looking back, and it was only a journey upward and forwards. In 2008, he was designated as senior counsel. And I remember in 2002, back in 2002, this was the observation about him. He said, when the Law Weekly said, Mr. K. Kannan is the chip of the old block, Mr. M.N. Krishnamurthy of the Kadalur Bar, the local Alladi who completed 61 years of practice in 1991 and passed away in April 2001. And it speaks a lot about his academic contributions, which I'll also shortly share with all of you. And it very interestingly says that both the late Justice S.S. Subramani, who used to be, and Justice Kannan used to be referred to in our bar as Dr. Johnson and Boswell made for each other. And the various books he edited, right from Farooq on the Indian Succession Act, Mullah on the Registration Act, Sarkar on specific relief, Modi's medical students, tomes of research, and at the rarest of rare distinction which a judge can get all through his tenure and even after that, this kind of lasting academic contribution. In 2008, he was elevated to the bench of the Madras High Court. He was later transferred to the Punjab and Haryana High Court, where his contribution to the flow of precedent and to the socio-legal change was immense. And apart from many of his judgments on various areas of the law, including constitution, succession law, family law, areas of social concern, I remember the Manmeet Singh judgment on honor killing as an earth-shattering judgment. It huge dialogue throughout the country on the whole subject of honor killing itself. And I very vividly recall the Punjab University in Chandigarh calling him for an event which was so well attended and well received. And after his retirement, Justice Kannan founded Madhyastham. Of course, he was the chairperson of the Railway Claims Tribunal, where he sought to change the organizational behavior itself and made a lasting contribution there as well. Later, he became the founder director of Madhyastham, a friendly outfit to popularize, train, and practice mediation. And all of this goes back to his own experience in 81, where in Kurunjipadi near Kadalur, he was accustoming himself to the mediating paradigm which was building at that point in time. In 2005, he became a mediator. He was awarded the Einstein Jams Fellowship much after retirement in 2017, where he had the opportunity to gain a wealth of experience from mediators in California and New York, apart from undergoing certificate courses in the Harvard Law School and the Hastings College of Law. And all in all, he's an expert mediator who has brought mediation to the next generation. And I'm sure that this talk on law and medicine, he's authored a very important book on law and medicine, which happens to be one of the reference books at School of Law, SASTRA University. And without any further ado, I would hand over the microphone to Justice Kannan.
Thank you so much, Amrit. I couldn't have expected anything better than what I'm hearing through you. I truly believe that I'll be able to live up to what all you believe that I possess. It's exciting for me whenever I meet with the students. Just that I'm not able to see you on standing, sitting before me, but it's just as much in the last few months, we have all gone through a certain kind of training of not meeting persons directly, but believing in that screen is all of you sitting there. So thank you very much for the organizers, and thanks also to Mr. Vaidhi Subramaniam, who invited me for this lecture. Sometime back, Amrit remembers in 2014, I was there soon after release of a book which I wrote, Law and Medicine. Many of my books are two things, law and medicine, wills and succession, landlord and tenant, accidents and compensation. Look at two things joining together. What do I understand, therefore, that law meets medicine? I have understood for long that the jurisprudential purity of what law is shall let us know what its latent potential can let us do in its intersection with so many other facets of life. If it meets with the human emotions, the rights, duties, and their denial, we'll be really discussing human rights law. If law meets with inventions, we'll be talking about the patents, trademark, copyrights. Same way, if medicine meets with inventions, it may refer to pharmaceutical industry and what it can do. If it meets with the patients, it probably talks about that patient care, the cure. So in the intersection of any two subjects, from a metaphysical point of view, we want to know a little bit of philosophy there emerges always something very new. Even Marx was talking about a thesis, antithesis, and a synthesis of what happens. When he's talking, he was trying to explain a class conflict which yields to something. So something that brings compound and complex issues, complex relationships, probably when we are talking about two persons having a conflict. So when law meets with justice, it can let us, for our purpose today, I thought these are the subjects which I'll take. If law meets with education, for instance, and medical education particularly, the recent worries of people have about NEET. Is it fair? What do we want to achieve? What does medical treatment really mean? How does he give consent? How does a patient give consent? What consent is informed consent? If it's meets with pandemic, it can yield multiple results. How is the state to be tasked to commit itself? That brings welfare to the people. And if it is tasked to regulate the spread of pandemic, what is required to do? If there is invention that brings about an antidote to the spread of the disease and gives a cure, and if that happens after a huge cost of research in a foreign country and it is getting imported here in India, what are the issues of patent? Last week you have had a couple of days, probably a couple of weeks back, you had a lecture. I don't know, it's probably a week. Justice Travasri there was there. Probably I should ask you one or two questions about how you have understood, how you have followed as I'm going along, because I plan to be also saying something about what can happen if a research product comes about in this situation. And if the medicine gets to be costly, what could be done? How does the decision in Novartis case, how does it impact? Does it have some lessons for us to learn? So, after all this, now, how do you understand by the tall claims of some Siddha and Ayurveda practitioners that they say that they have an antidote already in their system of medicine? The magical claims of cure for certain of the diseases. Can there be advertisements promising cure? Can such advertisements be prevented? All those are our issues of law today, or what I'm going to be discussing with you. First, I thought that medical education is a matter of importance. It is there in the paper. A couple of days back, somebody falls into the well, and you have a leader of a political party saying that for this reason, we must stop this NEET right through India. This happened. It was a Medical Council of India which sets the standards of education. And they say, with given limited resources, there has to be always some method of filtration. So that filtration happens through setting examination for students and get a number which is appropriate to the number of seats which are available. Now, there are a lot of private institutions which have come up. They don't take aid from the state. So therefore, when NEET came, and there are also minority institutions, you have the protection under Article 26, you have under 29 and 30, they have a right to establish and administer. So it came probably at the last time when I wrote my 2014 book, we had the decision just about that time, the judgment of Justice Altamas Kabir, and you had Justice Dave there in that. And that judgment and Vikramajit sin, it's a matter of keep it in your mind, among other things, that Altamas Kabir was a Muslim belonging to a minority community. Vikramajit sin was also a Christian, was also a minority. So it turned out, I'm not saying establishing anything, just have it in your mind that these were two judges who were writing the majority view. And they said, now, whatever system that you have, whatever system of filtering that you have, you won't be able to impose it to minority institutions, for that will offend Article 29, 30. And the right to administer cannot be in any way fettered. Establishment education institution cannot be fettered by these kind of examinations. Now, there was Justice Dave who wrote stringent dissent. And lucky for him, but these two persons who formed the majority retired immediately after this. And in fact, amongst the reasons for review, you'll be surprised. The reason for review, which is there, you have a look at that. That review is a very, very short judgment, running to probably about even just a page. And they said there was not even a discussion. This is what he said. There was not even a discussion amongst judges before the judgment was pronounced. So this was taken, among other things, to be a matter for review. And this was also stated there in the judgment. At the time when the review was given, they did not go into all the reasons or what should be normally the case. But they consigned it to be heard along with another case where the issue was from a dental education institution where common entry test, it was not NEET, common entry test. Is it possible? Do we have that? Can we impose it also? This was something which was taken in the year 2019 when KG Balakrishnan was the Chief Justice. He had caused a reference and this was waiting. So therefore, the bench of 3 became bench of 5 and the way sitting with 2 more, they referred the matter to a 5-member bench. So therefore, the reasons for the review come not immediately. It comes a little later in 2016. That is Medical Council of India versus the CMC, what it was. And that reference where they reviewed it in 2016 for SEC, that came to be rewritten, and the reasons were given in Modern Dental College. Dave originally, when he passed an order, he was again, when he was writing a dissent, he said that Article 29 and 30, they do not include the right to admit substandard students so as to produce substandard doctors by selling the medical seats to the highest bidder who pays money. These were as serious observations as that. Substandard students, substandard education, and then that is being sold. So these were expressions which Dave used. And then when Modern Dental College and Research, when in 2016, a constitutional bench ruled that states' insistence to CET, even to minority institutions, cannot be said to trample Article 29 and 30, or 26 and 30. So that's how the judgment went to full circle, where we started. But then, alongside this, there were also, you had the 93rd Amendment, where they said, they brought about Article 15(5), allowed scheduled caste and scheduled tribe quota to be observed, also for unaided and private non-minority institutions. This was upheld in Pramati Educational and Cultural Trust, matter of some interest for you to be seen. And Kerala said something. He said now, because during all this time when it was taking place, they tried to circumvent this NEET and said, now we'll regularize admission of those persons who have been already admitted. And they didn't go through NEET because there was a challenge before the Supreme Court. So they passed an order regularizing admissions. This was struck down. This is a later judgment that was in 2019. That is the Medical Council of India of the state of Kerala. But I want you to know one thing. You're all students, probably you have written exams and come. I'm a pro-reservationist. I'll declare to you. I think reservation has a lot of meaning. So even in some of the claims by the political leaders, I don't see this to be mere politics. Today there is a book getting released, which is The Tyranny of Merit by Sandel. See, he's talking about how we need a public good as the central focal point for recognizing the person's worth. And he also gives an example during what has happened during COVID of those delivery executives, or how they're called. And I'm glad that you have a good expression like delivery executive. It's not a delivery boy, it's a delivery executive. I like it. And also, he says about this value of these contributions. How do we not see them appropriately? You must again see in COVID, it suddenly brought to us a realization that every treatment, the treatment gets to be so costly. They have to come to Chennai. If those big hospitals are what they charge for a day at 1 lakh. Imagine that there is a whole lot of doctor community there available there in the rural sectors as well. Not at all times, merit is the only criterion for the places that persons must occupy. We have reasons to have doctors spread all across the society. When I was giving you some illustration about how there were two judges who both of them are minority judges, in the sense they belong to minority community. Look at the judgment. Or do we ever say that they were conditioned by the fact that they were minorities and therefore they were protecting minorities? It would probably be even contempt of court if I should even suggest something like that. I wouldn't say that. But you must remember, we all carry some baggages. We need a reasonably good representation everywhere. If you think we must have fairly a representative body amongst judges when they're sitting, the same way I would like to see the doctors. The doctors must be coming from various places, from villages. I should see more village doctors. Why are we thinking, did you know that in Kerala, you have some order which says every doctor who passes out must work in a village for so many things? Do we require orders like that? Does it not offend you that we should have people normally going to those places to work, places where attention is so important? Lives are so important to every person, be he in a metropolitan city or in a village. Life is precious. So therefore, that doctors must come from all places, and therefore our admission criteria must be reasonably different. And it is anybody's knowledge that a person coming from a village cannot compete effectively to a person who is probably studying in one of the finest colleges in Chennai or probably in Delhi. They can't be a match. But then once they are admitted, do they get any preferences? They don't. They go through the same examination. So Sandel makes a point that in Princeton University, look at all these Ivy colleges, and he says that 1% of the population of those persons' children alone make it to 75% of the persons in those colleges. It has something to say that persons who are privileged get privileged sons. Those privileges get passed on to the next generation as well. Should that be the criterion? No, social justice and reservation. I'm sure your university will give me some occasion to speak to you. At that time, I'll come back. But then I wanted you to remember, when we're talking about NEET, there is a strong reason why there is a resentment. So even if I say that the decision in modern dental College makes a strong point for NEET as essential, and it is the medical college admissions we are talking about. Therefore, the doctors must be persons of extraordinary merit. Granted, let there be merit, but let there be persons from all places. That's essential. Is what we need to know. That's the way we'll understand that law. And now, I was talking about how in COVID, in some situations, persons are not sufficiently serviced, and therefore you must know what the law is about that. We had the Epidemic Act. This came, it was a vintage legislation of 1897. That was a time when in Mumbai, at the time, not in Mumbai, in Bombay presidency in Mandvi, which is now in Gujarat, and there was a bubonic plague. And the Bombay presidency was densely populated, and there was a rapid growth of commerce there, a lot of people there. And the plague epidemic also spread rapidly. They wanted to put a stop, they wanted to arrest it, and they thought a legislation which will give some kind of, which will impose some restrictions on movement would be necessary. And the British Parliament at the time legislated for us. And that was how in 1897 we had the Act. And the provisions of the Act, there are just 4 provisions, and there is nothing extraordinary. You'll be surprised. For they had nothing to do about administering medicine, how to prevent and things. They looked at it from a very narrow point of view. And they can inspect a person who is traveling and stop them from traveling, find out whether this person has any ailment, and they can prevent him. And if any person is found to have that, he can be segregated and directed not to go. Beyond that, it didn't contain anything. They could inspect any place. That was the power of inspection is provided there. But this was used in a very strange way. You can't fault the colonizers. What else do you expect? They had their own reasons, and they were able to use it to inspect any place, get into any house, arrest any person, keep him aside. So it was not necessarily a person who could have some infection who had to be segregated. They found even political dissenters could be segregated under this act, and that was how it was used. But then it's 120 years old. We didn't have any enactment. What we are now doing, the one thing that happened in Tamil Nadu, when C. Rajagopalachari, Rajaji was the chief minister, Dr. Rajan was there. He was the person. Dr. Rajan was an extraordinary person. You're all near Tiruchi, and therefore you should know. Please check up and find out what all he did. It was extraordinary. He was a doctor who had trained. He was an FRCS from London, and he devoted his time to treating persons. And then when Gandhi gave a call for all those persons to give up their professions and come for freedom movement, he aligned himself. And I had occasion to read some of Kalki when I was to release a book. I realized there were so many youngsters who were inspired. And Kalki, for instance, didn't complete his school. And he left the school and went and to the call of Rajan. For him, Gandhi was a bigger figure, but the persons who mattered were persons like Rajan. Rajan was the person in the year 1939 who was instrumental when Rajaji was there to have a Public Health Act of 1939. This was the first legislation where you have, Tamil Nadu is fortunate to have some legislation where you can take over buildings. You can, doctors, the district superintendent, the powers of what the Act provides. Not many state laws have any such thing, because this was provincial legislation. And Maharashtra, Punjab, Gujarat, Assam, they issued notifications. They had to go to notifications in the Epidemic Act. They didn't have an act like what we have. So therefore, it was not the first time where we have felt the deficit of a legislation which can effectively deal with the situation. You had in 2005, the United Nations, they called to order a need for a national health incentivize or inspire states to come with their own legislation. We have, students of Constitution will know, we have Clinical Establishment Act, where states, state assemblies, they passed resolutions called, requested the central government to make a legislation. Central government made a legislation, a model law, which could be adopted by these states. And that's how the Clinical Establishment Act came. And we have also a clinical establishment in Tamil Nadu. We have also adopted a similar legislation where a state the central legislates for the benefit of the states. And when there is a notification, when there is a assembly resolutions requesting the center to do, they could do. And somewhere that kind of inspirational activities could not be undertaken. And evidently Public Health Act remained only when some states like Tamil Nadu had, and probably some other, Madhya Pradesh, I think also had, some other states had, but that was not sufficient. And this Public National Health Act also couldn't, the bill couldn't be passed as an act. And now with COVID-19, it becomes exceedingly important. We should know as students of law what is happening. A writ petition was filed. So what happens now if students of law will get inspired probably when you hear about public interest litigation? There is, why will we not take up something of public interest, just not dispute between two persons? It's all fine. But then public interest litigation by a lawyer, which is now seen in the judgment of the first court with the Chief Justice of India, Bopanna and Ramasubramaniam. Whenever you find somebody from Tamil Nadu, you immediately warm up, don't you? So I warm up to what all was stated. After all, a good friend and a wonderful judge and a human being of extraordinary caliber and character. So I'm sure you can recognize who has written that order. You can see those three persons have written. But then if there is a penchant for research for some person, that gets exhibited everywhere. Even in that 15-page judgment, there's such a beautiful exposition of how it is the state which the state is the law, and therefore it says something. There are very interesting passages of what the judgment gives. It says health has always been a state subject, so bring it as a matter of fact. And then public health, right from that, it traces the history of how it fell in entry 3 in part 2 relating to provincial subjects in the Government of India Act of 1919, and later it was entry 14 of part 2 in Government of India Act of 1935, and then in the Constitution when we have it, we have a legislation. Public health comes, I think, is entry 6 in part 2. And I was telling you, I was not too sure at that time. I think apart from Tamil Nadu, you had in Andhra Pradesh, because they had, when Andhra Pradesh went as a separate state, many of the Madras legislation, they were all immediately adapted in Andhra Pradesh. Therefore, Andhra Pradesh had that. It's the same way also in Kerala, many of those legislation. And Travancore Cochin, they was looking at all times on guidance from the Madras presidency, and therefore they also had a legislation. Pondicherry, it's our sister state, and therefore you have also Pondicherry at all times saying whatever Tamil Nadu is doing, they will also do. So we had the Public Health Act in some of the places, but then public health is still an issue now where we don't have a legislation. Therefore, this public health bill brought out some things. The lawyer has, the person who has gone on public interest, says these were the prayers. Look at what is happening. Look at the concern. I'm sure this is how public interest must come. But then if we don't do research and then merely present a case and then say, do this, do that, you expect the Supreme Court to do everything. And that's what is it that we do? If the Supreme Court doesn't do, immediately you say the courts are not properly making proper interventions. Expect too many things from courts, but on an important subject like this, which concerns the whole of the world, I think in India, at least we are now seeing some direction happening. Some states have done well. The prayer was, among other things, I've known of a relative who had not even, it's a suspicion of COVID, and then you go to your hospital, the hospital rips you for ₹1,00,000, ₹1,08,000, ₹8,442, something like that. So therefore, this is how the billing is made for drugs and disposables for a day. Drug and disposable for a day is ₹38,000. I know what medicine was being administered to the person, nothing at all, some Zincovit or something like that. And then they were giving prescriptions like that. You tell a doctor will always be unhappy. So you don't know what kind of expenditure we have. So therefore, there was a prayer there that they must regulate the cost of treatment. That is relevant, is what the person has gone to Supreme Court with. And they also say now the union government must mandate private hospitals to set up on public land and allocated at concessional rates, treatments, sheds and things which can reduce the cost. And then if it is necessary for so many poor patients, the state government or the union must bear the cost of expenditure, cost of treatment. That is what is the prayer. So in that, what the Supreme Court realized that it's not all about the central enactment is not possible. So because what we are now seeing, if the Prime Minister was able to give out calls for persons to stay indoors and things, we were invoking the disaster management provisions. So therefore, there were notifications coming. But could they mandate? We still had persons going to high courts and say, now let the hospitals not overcharge, or Chief Minister now and then to say, if you are going to do anything like that, we'll take action, these kind of threats. Beyond threats, there must be a proper regulation and a law which takes care of all these situations. And therefore now the Supreme Court is in Sachin Jain versus Union of India has directed that the state ministers, the health secretaries and the establishment will look into what is required to be done. Come to us with your blueprint of what you're planning to do. And we have, fortunately, the National Health Bill contains, Sachin Jain makes a reference about the fact that the first definition is affordable. In fact, it warms my heart to know that some affordability as an aspect which the government is actively thinking is so essential. And if it can come through proper legislation, which I believe, which should come, or the center is able to do something, or we have, because Tamil Nadu has it. But with that, are we doing sufficiently, effectively? Those are issues, because you know how powerful hospitals can create powerful situations even for states. So therefore it requires the willpower for the state to say what is essential, how it is to be done. But I believe there is some hope with the judgment which could be passed, with all state players coming on board and then revealing what they can do to improve situation to something close to the National Health Bill of 2009 proposed. So I would expect something to come in that way. Now, that leads us to, again, another matter relating to COVID thing. There is research going all over, and that research may probably lead to coming with some vaccine. If vaccine, where everyone realizes there is so much of cost which is involved, research doesn't come with no money there. A lot of private players put the money. And from Russia, Putin can always come out with something deadly. He will say he is the first one to do everything. His own daughter, therefore, he makes out a case of his daughter as the first person amongst the other persons to have gone through a clinical trial, subjected us into trial, and they have answers. We don't yet know, but it could come. But what happens if those medicines, if it can be manufactured, invented in India, it's great. But with facilities, we have done rather well in the area of pharmaceuticals. Our treatments, our things have been extraordinary. But what India has been truly popular is the production of generic drugs, and what our pharmaceutical industry is able to do, and the medicines which we make them available at such low cost that all over Africa and many of those poor countries as well, If they can afford treatment and medicine, it's thanks to our pharmaceutical industry. We have been leaders in that kind of production of generic drugs, where before the advent of the TRIPS regime, where you had only process patent and not product patent. It was possible to go through a reverse engineering and then gather what is a particular invention product is, because a product patent was not available. Now product patent is essential post TRIPS, and we have amendments also under the Patents Act which recognizes that. And there are difficulties. But then Justice Prabha had spoken to you, I'm sure you'll remember, that what drives inventions. You have what are the principles which are available for patent. Among other things, the most important issue will be public interest, and therefore if an invention is made, it cannot be merely to be kept in a closet at a high price, which can be claimed only by paying the price, that it ought to be available. There cannot be a monopoly situation that can abnegate a public interest. That is amongst the other driving principles of what Section 83 says. And again, you have provision on 102 of the Patent Act, which says the government can acquire a patent if it is of utmost public interest that it acquires it. And then what will be the compensation paid to that person? Any acquisition requires compensation to be paid. Although in the constitutional scheme of things, the adequacy of compensation itself cannot be at all times assured. It is possible for you to reduce compensation and say why it should be reduced. So state can come with some policy. I would expect, therefore, if any invention takes place in any part of the world, it will become a matter of utmost interest for the government to acquire it, or if it doesn't acquire, by the sheer kind of volume, the population that we have and the consumers who are likely to be there, I would expect the price to be not a major issue. There are sufficient provisions in the Patent Act which can effectively regulate the pricing relating to that. So notwithstanding, Novartis, we were able to come out in a different way. We came through 3D thing that it does not really invent something. We brought it as not coming as an invention, the way 3D defined. So therefore, it was possible to come in a different way. But now is a thing, there is no other medicine which is already there. You also heard about expressions of evergreening. You merely add something, make it seem like a new thing. It can't be anything like that for COVID. It has to be something wholly new, newly invented. It's a novel COVID, is what they say. Novel COVID is because you don't know what are all the organs which can be affected by this COVID. And that's as serious as how it is. So from there, you also see what do we do about, or what do you, have you not heard about some person saying that we have in our system answers? And some of the funny things also happen, and therefore I should tell you that there is Suman Haripriya. She made a statement in March that she is an elected member of the ruling party. And she said cow urine and cow dung could be used to combat the outbreak. So, and Chakrapani Maharaj, your leader, he said that he would organize an event to educate people on the use of the cow products. So as you worship the cow, we also have a constitutional duty to have scientific temper. So if you have statements like this, or somebody like what somebody said in Rajasthan, that peacock sheds tears, and that's what is making possible the procreation. So you have these kind of funny statements released. How do you prevent? Can you prevent this? I'm not too sure, but there is law. Baba Ramdev also said that he has answers for that. And in fact, what had happened was something extraordinary. He also went to one step more and said that we have conducted our clinical trials, and they're showing that the wonderful results. And he had, therefore, Coronil or something is what he produced. And the injunction came from our court, from Madras High Court only. Surprisingly, not by any other person. saying that this product is not really going to prevent. It was a chemical company which had a similar name. So they said, no, you can't have coronil. We have a chemical like that, and it's likely to mislead people. And Baba Ramdev produces chemical, non-chemicals, powder, not powder. So all kind of things, therefore let him not do that. Court grants an injunction. He went to Supreme Court. There also he lost. But then these are things that there are lot of claims by our native practitioners. There's nothing wrong making claims. But then if you would know that in these days, our Drugs Act talks about various stages. And those are important provisions of where you have under the Drugs Act of the protocol which is there for clinical trials, and the way it has to be done, how it has to start with some animal experiment on animals and or insects or other things, small things, not on human beings, and then take it next stage to human beings, provide for a regime of compensation, take informed consent, and give out a pamphlet as to what are all the protections which are available, what is the backup for treatment. It goes through quite a drill before you can say that we have gone through this, we have found that there is a good effect, and that we are able to establish that this has a cure. So therefore, it requires several stages to be passed, and every country has very serious provisions about protection because we are trying to create an antibody. Some small thing will be from that virus itself will be injected, or in some way it will be manipulated, so that there is some element of risk which is involved. And how do you guard against that kind of risk is how you'll be seen. So therefore, I would expect anything of what is happening, if it merely turns out that you have not gone through the drill and say that I have produced something, it can be, a person can be prosecuted. And there is a Magic Remedies Prevention Act, and it contains all penal provisions. It's possible for you to be stopped. And that's what, when Baba Ramdev said, the Union Ministry asked him, what are the trials which you have, give us all the results. And then they clamped a restriction on this claim. So therefore, there are provisions enough to prohibit any false advertisements being made. I talked about in the clinical trials and informed consent, and that is an important change of law what has come now. It has come not from any of the high courts, but it has come from a national commission. Judgment which is rather strange, because I received a lot of mails and concerned letters from several of the doctors, because I've had occasion to meet with doctors, address them at various conferences. So therefore, the National Commission, this was one case where Vinod Khanna was this RG Stone Urology and Laparoscopy Hospital. This was a Delhi hospital somewhere in Gurgaon, I think, Faridabad or Gurgaon, I'm not too sure. This was a case about a person claiming that the treatment did not give the desired results, and it was serious. The person had some problem. He was laparoscopically treated, and he was passing urine through anus. Look at that. That's not a very comfortable experience for a person to be passing urine through some other organ. And it was, therefore, he took action for negligence, professional negligence. And the National Commission set aside the orders originally passed by the courts below, by the State Commission. And then it said the doctor is not responsible for that. There had been a proper informed consent. A proper informed consent, therefore, if it was, if he had understood that there was risk possible in a laparoscopic intervention, and that kind of a orifice can get, the urine can get deflected elsewhere through another orifice, and over a period of time it can get treated, or by some corrective surgery it is possible. And this was expressed to him, that was told to the patient sufficiently. Then there is no question of any medical negligence. The court therefore said there is no medical negligence, he had been properly informed. But surprisingly, the National Commission says to 2 members there, this was a judgment sometime in May 2020. The National Commission says that there was an unfair trade practice which has been done. The unfair trade practice was that the hospital informed consent form had a blank space for the name of the doctor, and the type of treatment which was done. So these were the blank. All other expressions were all printed. Like everything has been explained to them, all the risks connected to that particular kind of treatment has been explained. So this person knows what is happening. So every other information is there, and you merely fill in this just small things, like 3 things: the nature of treatment, the name, the doctor who is treating. They said it was not sufficient. This cannot mean that anything has been properly done. So if the imposed 10 lakh compensation against the hospital, and that did not grant that again to the person who was passing urine through his anus, he directed the money to go to the legal aid clinic. I think in every form, the judgment is wrong that way. That's a National Commission. I believe that there is going to be SLP before the Supreme Court. And he's a good person, actually. The doctor who has written the judgment was himself a doctor. Dr. Kantikar has written that. And I think he has raised a correct issue. The correct issue is that, can you have this kind of cyclostyle forms or merely the name of the thing, where you give no detail of any treatment which is to be given, the nature of risk which is exposed, which a person is exposed to. Without any of those things, can you say that there was even a proper informed consent? He could have easily therefore said this was bad, and therefore there could not have been informed consent. He says there is informed consent. How could there have been informed consent if it was only a form like this? If you are prepared to accept an evidence that what the document does not contain, those risks was also explained, then this did not cause any problem to the patient. And therefore, the question of unfair trade practice does not arise. But anyway, that's what the National Commission said. But we need to know that there is an important change of law which has come. In Samira Kohli, Justice Ravindran wrote an extraordinarily sensitive judgment. Justice Ravindran is capable of writing unbelievable judgments. See, just as students of law, you must know which judge you must go after. If you're reading something of Justice Ravindran, I'll sit up and see what has he to say. That's a kind of man. He can say things with extraordinary lucidity. He'll make it so simple. And he had taken up issues in so many judgments. His judgments have really stood that long. Every other judgment will follow that. If you have in Pranay Sethi how to determine compensation, you'll have to go to Sarla Verma. There is no other way. That is the way compensation has to be determined. So he can bring a certainty to approach. And therefore, his judgment in Samira Kohli is still the best exposition on informed consent. Why am I taking reference to informed consent? Because Justice Ravindran saw in India, there is a kind of a medical paternalism. That's what he would say. Medical paternalism is when you believe a doctor to be your father, you is your doctor, he is your God. So you go to him and then you present yourself with your ailment. The doctor, whatever he says, the doctor says there are some risks. Ayya, neenga paathu sonna serida. Doctor ayya, neenga sonna serida. So therefore, whatever the doctor says is fine. That is the way I would trust the doctor. That's how it was. So therefore, he said, if this is a kind of an attitude for people, for the doctors, it would be too unnatural and artificial to be expecting him to be telling a patient of everything which is required to be done. What are all the risks which are there? So, but would that mean the doctor doesn't need to say something? He therefore looked to a principle which has been evolved, which was a Bolam principle in a Bolam case in 1957. They say whether a particular kind of treatment conforms to the standard of practice, the standard of administration of treatment, has it been adopted in that case. If that is done, then it is fine. This is what was Bolam. In Canterbury, which was a 1977 case, 74 year case, they were looking at it in USA differently. They said they put extraordinary stringent standards there, which would require, was this expected of this kind of expert? Or was this expert capable of delivering a thing with no blemish possible? Would not a person in such a situation also require what were all the alternatives which were available? Was the patient informed of those alternatives so that the patient takes an informed decision of whether this kind of exposure to a particular kind of risk by this doctor will be acceptable or not? So therefore, the Supreme Court is looking at Bolam and Canterbury and preferred we will not, in Indian situation, look for an informed consent to that kind of extracting standards which Canterbury gives us. We would rather be satisfied with the Bolam principle. So this has held for quite some time. But then the country which had Bolam has changed now. They are looking at it very differently, and this has come through the judgment in Montgomery. In that judgment, it was a case of a person where she was diminutive in size. She had she was a diabetic, and she was expecting a child. And this person, when she went for treatment, the hospital looked at her profile, found everything was in order, and they decided on a natural delivery through vagina. And what had happened was the child that was born had a problem. The child could not be negotiated through pelvis, and the child had brain damage. And this was possible in situations. I'm just now looking at that particular thing of there was a 9 to 10% chance of a diabetic patient developing the risk of shoulder dystocia. The shoulder dystocia is something which you can probably even see in the YouTube these days. So much of information which is available. You can even see at YouTube how the child is delivered. And when a child's neck can get entangled somewhere there in the pelvic bone, and it can be negotiated and taken. And if you need to be, any doctor at any time will require to see that there is an adequate care which a person gives and delivers the child. And there is a 8 to 10% in cases where a person is gestational diabetes also possible during the time of delivery. Just at the time in advanced stages of pregnancy, a person could have high levels of sugar where it impacts in some way the pelvic bone, and the child delivery becomes a problem. And that is about 9 to 10% percentage of risk which is always there. And this child which was delivered, such a thing could have a brachial plexus injury, which is 0.2%, prolonged hypoxia resulting in cerebral palsy, that is 0.1%. Poor child, 0.2% and 0.1%. The child had palsy, the child had the difficulty, this brachial plexus injury the child suffered. So this person has taken a doctor for compensation claim for medical negligence. And the answer by the hospital was that this is a case where there was an informed consent. She had been informed about the dangers possible. The alternative to a situation, if there was anything, was only a cesarean section. And while cesarean may be just the usual practice here in many of the hospitals, because that also is a money spinner for them, in foreign countries, you won't be able to do that. There are many parents, many mothers who would say, now I should have the pleasure of the pain of delivery. I need to know what it is. And you prevented me from delivering my child through a normal fashion. You made a cesarean, I take you to court for compensation. That was all possible. There are cases and there are decisions like that. So this doctor, the hospital did not think of delivering the child through Caesar, but thought it was fine. There's a 9-10% risk. It's not a big deal. But they said, now, this is standard practice. This is not sufficient. You need to tell the person everything of what is essential. And if you have not done that, and if you are not given several options, you must say this 9% chance. There was a 10% chance. There is 0.102% chance of a risk of a child getting affected. Every one of those details must be shared with that person, is what they say. So this judgment in Montgomery is likely to affect Indian law, because we followed Bolam. We thought, well, now Montgomery goes one step more than Canterbury. So therefore, I'm expecting something soon from some judgment where we are able to establish something. From Samira Kohli, we need that distance. It's essential we need this. And take it along with what the National Commission has said now. Don't have merely the cyclostyle forms which would fill in all things have been explained. They've all accepted. This is not fair. And these are days where you have everything immediately photographed. Even a person getting beaten somewhere by police in some place, you take photograph. You don't try to prevent it. You take photograph from all directions, all angles. So we have those kind of propensities of taking photographs. We enjoy doing that. But these days, at a time, I'm sure there must also be some judgment which says any person who is administered any surgical intervention or major treatment regimen, that person, when he is being informed about the risk, it should all be videographed. After all, now many of the postmortems are videographed. There are judgments which require that kind of postmortem to be done, if it is postmortem to be videographed. And therefore, this must also come through that kind of system. I also say, I'm writing on Registration Act and things. Many of the registration processes, impersonation and things will go if we have a digital recording of the whole process, so that bill can never be denied as being brought about through a person who did not know what the document was. If only we can videograph that and make it available, and the registrar gives to you not merely the registered document, but also gives to you in a pen drive the whole process of what was happening. So therefore, I expect this law to also go for a change. And as I see the time ticking away, I would also say this as a thing from the time of what I wrote in the time in 2014. At the time, I wrote in my book, and later also in medical jurisprudence in Modi, that the judgment 377, what was set aside in Kaushal by Justice Singhvi and Mukhopadhyay. We need to know those judges' names, at least keep them. What law, who arrested, some development of law, from where it took another side. We'll know those judges. When you read at all times, always see who those judges are, who are the lawyers who are doing this. All that add interesting facets of understanding what they're capable of doing, what you should. I was already telling you how certain judgments you'll have to go after. So this judgment, a very conservative expression of what was possible, what was against human nature, and therefore to be criminalized. And the Supreme Court said at that time that is such a low percentage of persons who are homosexuals, and said a minuscule fraction of the country's population constitutes lesbians and gays. If it was minuscule, I should be all the more concerned that after all it could be taken care of. If they have a preference, what's wrong is what they must have said. But then they didn't say like that. And it had to wait till 2018 in Navtej Singh Johar versus Union of India. We had a change in law, and there was a judgment by Deepak Mishra, Rohinton, Chandrachud, Kanvilkar, and Indu Malhotra. Everyone except Kanvilkar wrote the judgment. Kanvilkar at all times, even now he's in the Supreme Court. He normally was there with Deepak Mishra. He supported him in writing several judgments. He didn't write the judgment himself, but all others had sure concerns about individual liberties and preferences of consenting adults, or what they do within closed spaces. How could that be ever an offense, is what they said. By that time in 2018, we also had pronouncements from various forums, and particularly of the Supreme Court in US. US Supreme Court had to do about same-sex marriages. We have not gone that far. What was in same-sex marriage in US was Michigan, Kentucky, Tennessee, Ohio. These state legislation defined marriage as something. That was what was surprising. Marriage was a union between a man and a woman. That was the definition of marriage. This definition of marriage was the point in question. So therefore, they were looking beyond mere same-sex sexual sex by consent. They were saying beyond that must be stage where they could also marry. This came through some case in Texas where a person, two males married each other from a state which permitted same-sex marriages. Probably they were from Nevada. They had the marriage. They came and settled down there in a state where they did not, in that place, it was not recognized. One person died, another person was claiming succession. There was a problem. He could not have been the person who could succeed lawfully, was the question which was taken. So in that, they went as far as that, and they said it was possible. One more judgment of what is somewhere in relation to same-sex marriages, lesbian, gay, is transgender issues. It is exceedingly sensitive, and in Nalsa versus Union of India, Justice Sikri and Radhakrishnan, both of them have written judgments. Both of them are brilliant pieces. I want you to read 2014 decision. Please see how sensitive the approaches have been. They've also given so many directives to the government as to how it can improve. And therefore, for us, happily in Kerala, you had appointments in railways where transgenders were taken. Probably they gave a percentage. Even this judgment talks about a reservation for transgenders, that we recognize persons who require to be supported. I've seen it myself in a case. With this, I will close my talk. Sitting in the railway claim, I found that there was a person, there were a group of transgenders. We have driven them to a situation where they have to be begging. There is no respectability that we give. Therefore, they don't have any respectable jobs. And they were probably, somebody was begging. There was a bank employee from Tambaram. That man was probably resisting. I don't know what he did. There was a small altercation there at the railway station, and the man was pushed by this transgender. She was called as Vignesh alias Shanti. I'm giving the name because a person declares her own sex as a woman, and therefore the police still takes Vignesh alias Shanti, which was unnecessary, and takes the person to prison, to the police custody. And then 3 days later, Vignesh is reported to have died a natural death and reported to the magistrate, and they closed the case. That's all. The case came to me for that man, the bank employee who died. I provided some compensation because an untoward incident, I said. But the way the case had been closed, it still shows. Now, this was a recent judgment of the year 2019 from Tambaram, from what had happened. So therefore, these kind of things still exist. If we don't give respectability, if we sodomize and kill there's also a very sensitive picture in Tamil. I'm glad that kind of movies are made. And I like the picture because it showed the kind of problems with their face. And that's a tough life. So we have not given them respectability, but then there is still the law which makes it possible is what we need to know. So that's 12 o'clock for you and 12:03. So I'll conclude this with certain aspects of what I thought would be necessary on issue of from medical education to of COVID situation to the inventions to informed consent to homosexuality where it is. So these are some of the areas. I'm sure your college management says, no, it will be part 1, part 2, and part 2, I'll threaten you with something where I'll say, why men rape is something which I would like to speak to you about. What is about passive euthanasia? And then what are the limits of DNA evidence? Those are exceedingly relevant in these days of science. How much of it is science? Where is the risk which is involved? And surrogacy, the way we are not able to make the law, but it's all governed through some judicial pronouncements which are very patchy in their approach, and through government orders, all of which can be very easily skirted. So, and medical termination of pregnancy also gets to be a very important area. For what I wrote in Hindu some time back, there was a trenchant criticism of what I wrote, where I said, after all, young persons can experiment in their body. They like to see what things are happening. They suddenly raise the age of consent to 18. There are still youngsters who are grown, reasonably mature to know what they're doing. So we somewhere pushed our law in ways. There was a knee-jerk reaction to what had happened. and therefore push the age of consent. But then consensual sex takes place with persons who are less than 18, but that is rape now. And termination of pregnancy and issues of pregnancy get to be the most natural thing. How it can be done, who can give a consent, what kind of counseling is possible. Counseling procedures of what Germany declares as possible in every situation before a termination of pregnancy does. Could it be thought of in India and brought through legislative mainstreaming? These are issues which I'm sure we'll be able to discuss the next time. Thank you very much. If there are some questions, we'll be able to handle those questions.
Thank you very much, sir, for that multi-thematic lecture, which spanned so many areas in law and medicine. And I must tell all our viewers, especially our students, that Justice Kannan's book on medicine and law is, I think, a standard reader that no law student must miss. And I would urge all of you to get it somehow and read it, not just as part of your course, but also as part of general learning in law itself. So there are, I believe, 3 questions, and I'll just ask them one by one. 3 of student friends have sent it. The first question relates to the guidelines in the Parmanand Katara case. In cases of admission in of emergency cases in hospitals, where without admission procedure, can it be extended to severe COVID emergency cases, and can hospitals deny such admission itself just by saying that these guidelines are there, therefore even if there's emergency COVID, I can't admit? Is that an offense? Is the first question.
Now look at this clinical, among other things, I can tell you this Clinical Establishments Act, which is notified, and we have also passed that legislation. Don't think about hospitals. I'm talking about clinics. No person can deny admission to any person. It's an offense. And therefore, what do we talk about emergency situations where somebody says, no, we won't do? They can't do. In fact, eternal judgment from the Supreme Court, which was dealing with a case from Calcutta, was a decision where the person, when he was taken, he was an accident victim. He was being taken by some person who was not a relative. Taken to the hospital, that hospital says, how are you related? He says, no, I'm a passerby. I saw the person ill, and therefore I brought him there. Please deposit the money. He says, I can't do that. They turn the patient away, and the person dies within a short time. And in a case before the National Commission, which went up to Supreme Court, the Supreme Court said, the hospital has no business to turn down treatment or say that that person has not deposited money and therefore it can't be given. And more so, therefore, in a COVID situation where we have not found anything, then you need to at least manage a person to give them a kind of a first aid of what we are seeing, or make possible ventilation, and so that the person is able to breathe. An artificial breathing can be induced through instruments which are there. You don't, therefore, immediately cure something, but then you manage a patient. So there is no question of a person turning a person away. So I would say that it's very essential that a person is taken on board, taken to the hospital, and every kind of treatment is attempted. And no explanation, no kind of excuse from any hospital will be possible. Even if it's a clinic, leave alone hospitals.
And this question was asked by a 4th year BA LLB student, Vignesh Hariharan. The second question is by Aryan Atreya of the 2nd year BA LLB honors course. And his question relates to the International Health Regulations of 2005, which mandates state parties to report any situation that is capable of evolving into a global health emergency within 48 hours of making an internal assessment to the WHO. How important, he asks, is it in your opinion for nations and India in particular to adopt a regulatory procedural framework to assess such situations in the future to avert global catastrophes?
Yeah, Atreya, what was this? Arya and Atreya? Aryan. See, this is exactly what I was some time back saying, Arya, that our own National Health Bill of 2009 was a response to what was engineered through World Health Organization, United Nations, requiring the state parties to be bringing law in their respective countries. The world body giving directive and the state, India being a signatory, it could not have said there that we are entering into, we are signing this. And but however, in India, health is a state issue. We won't be able to legislate. You have in the constitution, you have provision, probably 256(2) or some provision where a center can make the law for the state. And they made that attempt. The bill of the year 2009 was the basis when a case was filed before the Supreme Court. The initial directions of what the Supreme Court is making, till a third member joins, another person of what we said. I would like to therefore see the judgment with greater interest now. You have that. They were not able to push it. They didn't think, oh, let it take its own course. And then have we not known that Parliament has several distractions, and therefore they couldn't think. Now is the time when probably they need to make that law. That is, therefore, what Tamil Nadu had, that we had a we had a State Health Act, which is reasonably sound. The State Health Act, of what I see, contains extraordinary provisions. If you should know some of those sections, I'm not going to read you through those sections, that it can have the power to abate nuisance, power to inspect any building, take over building, take them as hospitals, declare, like many of the hostels of what has happened there in Anna University and many other colleges, to declare them as hospital facilities. All that is possible only because of our enactment. And that wouldn't have been possible in every other state, because the national disaster management or something like that, they are too generic. We have a special health situation here. It's a health emergency. So therefore, what should not be possible at the time? There ought to be powerful legislative framework for this, in order that doctor feels sufficiently empowered. I was there part of a small committee of ethical committee for medical university. There, among other things, a proposal was made by one of the researchers saying, how do patients who have COVID, how do they get treated by their families? At the time, we were looking into what is there, what are the, and among the other things, what is the protection which is even available to the doctors? That was a concern from the hospital. And there were students, therefore, the college, the university also organized a debating topic for the students was, are doctors sufficiently protected to protect patients? So this was a topic for them. So we noticed that there are huge deficits. If only we have a proper legislation which will take note of all these deficits of what we see, our responses will not be ad hoc as they are now. A legislation normally takes into account several thinking. You have engagement with all stakeholders and try to find out what would all be necessary. That kind of an engagement is necessary with the doctors there, with the research people there from pharmaceutical industry. All the stakeholders must be brought on board to secure a law which gives a very strong basis for that. That surely is necessary, Arya.
Then there's one more question from Malavika, who is also a fourth-year BBA LLB student. And her question is about the public health system, which is in India, which is still developing, facing a lot of challenges, and especially during the COVID times, it shows. And in that case, the question is to you is, will nationalizing private hospitals like what Spain did, and private hospitals were thrown open to public free of cost, will help fight a COVID-like situation?
Yeah, you rather wish. That's why I'm saying national health bill had affordable treatment as an objective. Now, who does not know that treatment is not affordable anywhere? If you're talking about hospital treatment, they are doing great service. Who denies that? In fact, my friend who is a judge, not naming the person. He was referring to a maidservant in the house who had COVID, and thankfully the members of the family were not affected. This person, they had gone elsewhere to another place, and the servant was identified and taken by the hospital. The hospital, I think in Rajaji building or something like that, the hospital is all full at that time, and therefore she was taken there. And she has been fully treated. And the person was overwhelmed by the kind of love that she got at the place where she was getting treatment. So taking over places like Spain does, if you're saying like that, you look at Europe, many of those Europe countries are what make India. That's as big a country as we are. Spain or something is like a state, one state. They have the priorities. For instance, Australia, New Zealand, Canada, for instance, all treatment is free. In Australia, all treatment is free. They pay a flat tax of 30%. In New Zealand, it's the same thing. Ours, it's not like that. It's still that we allow for a lot of private players there. There's nothing wrong about private play there, but that person must be engineered only through public interest at all times. Gets to be a very difficult thing. A public company which establishes a hospital which calls for annual general body meetings where the chairman declares a dividend at the time, makes an announcement of dividend, and says how we are setting our target for more patients to be taken in. Could the concern be a non-profit making service only as an activity? It's difficult. So therefore, let us be realistic. While you will, so many of these hospitals that therefore they declare also that certain percentage of patients, it's expected also in the hospital administration when they're granted license, that they have access also, they provide access also to poor patients. But governments by themselves, if you look to the government is having all the initiative, there are problems the way we run them. If there is a policy announced by the Prime Minister and says 6,000 rupees will be transferred, and Tamil Nadu gets to be the first amongst other states as to where you can loot money of that money. So you go through the government process, there are bound to be these kind of leakages. So therefore, Spain has done it. Shall we do it immediately? I wouldn't want anything like that. But the state must be able to show the way of what it does. They have done rather well. All our hospitals, the government doctors and nurses are where they performed exceedingly well, exceedingly sensitively. Like I was saying, of some person was overwhelmed by the kind of love that the person was receiving from the hospital authorities. I'm sure that there are great examples, but that is not sufficient. But a lot of other people must be treating the same way, will not be charging extraordinarily. That will require to be done through regulation. A proper legislative backing must be there. Otherwise, merely a GO saying, or merely the Prime Minister, Chief Minister every now and then saying doctors who are treating hospitals which are taking a lot of money will be penalized, will be taking action. Against which big hospital will you be taking action? You will be sending your own son to that hospital for treatment that even. So therefore, those are very risky things. But legislative backing is necessary, Malavika. I think that's what is important.
Then there's one last question from Meenakshi, who's a final year student. Her question more relates to the claims of any medication being an Ayurvedic or a more indigenous medical benefit. And the long and short of it is, when a person without an MBBS degree cannot recommend medicines for cure in that field, should the same not apply for Ayurvedic medicines? And we have a lot of medicines being advertised on social media and the media saying that, this is Ayurvedic. So this kind of spurious advertising, especially in indigenous medicine, where does this stand?
We have an apex body like Ayush, which takes care of Ayurveda, Unani, and all other indigenous systems of medicine. They all come within a framework now of regulation. And if allopath cannot administer homeopathy, or homeopath doctor, there are decisions there. A homeopath doctor administering allopathy is per se negligence, is what they say. There are decisions like that from the Supreme Court as it went up to Supreme Court. So within Ayurveda also, that somebody can, no, they can't do, they cannot administer, they can't give, hand over anything like that. So there is surely regulation in place. So therefore, it is not possible for anyone to be advertising. So it's foolish for somebody to be talking about curing through Ayurveda yet, unless they have sure proof. Like what had happened through, there's a well-intentioned, see that we have our native systems of medicines, which at some point of time treated the person as a comprehensive whole. It did not merely treat a particular disease. Ayurveda is a holistic science. All that is fine. But we must marry a lot of research and important papers of trials and showing the proof as to how it has established your cure. That kind of a thing is essential. So I'm with you, Meenakshi, to say that there can't be advertisement. There are regulations now in place. Nobody can say that I can dispense with homeopathy medicine, because even if I'm not a homeopath, I can dispense with some Ayurveda. Even I'm not an Ayurveda. It can't be done. It has to be, these are all. But even in our system of medicines, even in allopathy, everything is not prescription drug. There are so many medicines, like any medical dispenser can dispense with probably analgesics, and that is not a prescription drug. So there are, in Ayurveda, there are so many things which may not be prescription drugs. There can be so many things which can be taken across the shelf. That won't be a problem. But somebody saying now you improve your immunity, you take with the salt every day. Now and then in WhatsApp, you may have any kind of messages about how much of turmeric you must add. You add one drop of lime there, you add this, that. You make your own concoctions. These are all fun types now. There is nothing very serious about these kind of prescriptions of what you see in WhatsApp. Don't get driven by that. But if there is anyone who is prescribing something, assuring you of a cure, and that person is not authorized to do so, and cure, if he does, I'm sure you are entitled to give a complaint to the police to say that the person is doing something which is wrong, because the Magic Remedies Act provides for penal provisions that can hound a person and prevent the person from doing what he is assuring a person. So therefore, that's how I would see that answer coming.
So thank you very much, sir. That brings us to the end of part 1. And I'm sure that we'll all await for part 2 of your lecture next month. And it's been more than an hour of a very invigorating session on various themes, as I said. And I'm sure that all of us have enjoyed it, and our viewers have also given great feedback already. And friends, that concludes our present session on Jus As They Teach, an academic initiative by the School of Law at SASTRA University, this time featuring Justice Kannan, former judge of the Punjab and Haryana High Court and former chairperson of the National Railway Claims Tribunal, for whom judging itself has been a spiritual journey all along. Thank you very much, sir, once again. And thank you all for being such a nice audience. Thank you.
Thanks, Amrit, for a wonderful time and the way you introduced me. Thank you very much.